Sorry about that.
You don't have to apologize to me for not being handsome.
Was I giving the bird on our broadcast, Law and Legitimacy? Welcome back, folks. Mike's telling me I'm looking a little tired. Well, maybe I am. I got in last night. I'm in Vermont. I got in, around midnight after being in Minneapolis, St. Paul the night before, arguing in the 8th Circuit Court of Appeals. So those of you who aren't lawyers, let me just nerd it out a little bit for you and explain how the federal courts work. We've talked about federalism ad nauseum here. A federal government and a state government each have their own court systems, and how those court systems interact and intersect with one another is a fascinating topic. And so yesterday, the federal courts, like state courts, have trial courts where issues of fact get decided. They have appellate courts where if you're dissatisfied with the results at the trial court, you can ask the appellate court to correct something. That's what an appeal is. You typically ask for a new trial or a reversal of a judgment, that sort of thing. And then sitting atop all of that is the United States Supreme Court, which resolves authoritatively all questions of federal law in the United States. And, we may or may not like the answers that we get from the Supreme Court, but somebody has to decide. So yesterday, so let me back up. There are two ways to get a case into federal court. There is what's called federal question jurisdiction, where you raise a matter of federal law and you take it right to the federal court. You don't have to do that. You can take a federal issue to a state court, because the state and federal courts have concurrent jurisdiction. And the manner in which they exercise that concurrent or simultaneous jurisdiction can be somewhat confusing and intriguing. So if you raise a federal question in state court, the other side has the right to remove it to federal court. They have to act promptly. You can also go to federal court under something called diversity jurisdiction. And diversity jurisdiction means that the parties are diverse.
Equity. It means equity.
Well, fair enough. Yeah.
I'm kidding.
Yeah, no.
DEI jurisdiction.
Oh, no, yeah. Oh, please. Yeah, no, you worked out. I didn't get enough sleep last night. Bam. Got me on that one. No, it doesn't mean DEI jurisdiction. It means that you're from diverse jurisdictions, different states, and so you go to federal courts. And then there's a complex body of law about which rules you apply if you're in federal court on diversity jurisdiction and so forth. So my office was retained by a man and his wife, Mr. and Mrs. Sellier, through the auspices of a group called We the Patriots USA. And I would encourage all of you to give a look to We the Patriots USA. It's a public advocacy group that believes that government is limited in its powers and that people ought to be sovereign over their own affairs. And it seeks to litigate in a variety of issues. It started out doing COVID-related litigation. It's now evolved into Second Amendment litigation. And, I'm one of their go-to lawyers, so I'm hawking my boss, I guess. But in any case, in the Sellier case, here's what happened. It's early in COVID-topia. The country is panicking. Are we all going to die? People are getting COVID and they're looking for what treatment they think or their doctors think will be efficacious. Mr. Sellier wants to take Ivermectin because he's read about Ivermectin. Most of the medical establishment doesn't want Ivermectin prescribed as a treatment for COVID. It is contraindicated according to many in the many medical professionals, including the most prestigious ones that set regulations. However, there are dissenting voices, and some physicians contend that ivermectin is efficacious, that is, useful to combat the symptoms of COVID. So Mr. Sellier, a Minnesota resident, sought, I'm not sure it's actually Minnesota. Mr. Sellier sought a physician to prescribe ivermectin, couldn't find one in his state, went out of state and found a physician. The physician phoned in a prescription for ivermectin to a Minnesota pharmacy. Now, let's break down the fundamentals here. A man is sick. He goes to a doctor. There is a patient-physician privilege. He discloses his medical condition under cloak of the privilege to his physician. The physician is licensed and the physician makes an informed judgment that he's going to prescribe ivermectin. It's an unpopular decision, but it's a decision that the in many quarters that the physician made. And so the physician gives him a script, gives him the ability to fill a prescription, takes it to Walmart, a Walmart pharmacy, and the pharmacist says, "What are you taking this for?" And COVID. And well, you can't do that. Our guidelines don't allow us to prescribe COVID here. We'll talk to, but there is a Minnesota regulation that requires a pharmacist who's going to not fill a prescription to contact the doctor. So he contacts the doctor, and the doctor says, "Oh yes, in my judgment and in my opinion, this patient should have that." Well, you can't do that. That's not right, the pharmacist says, and he refuses to fill the prescription. As a result, Sawyer resorts to using a veterinary paste and modifies some ivermectin, he and his wife himself, based on what they read online, and they give it to themselves, and they live happily ever after. So they brought an action against Walmart, and by the way, Walmart is not a Minnesota corporation. So Sawyer is from Minnesota. Walmart's a foreign corporation. I don't know why they didn't find a Minnesota lawyer to bring the case. Maybe no one would touch it. So we did on behalf of We the People, and we filed in federal court because the federal rules are what they are. I mean, if you're active in practicing in federal court, you know them. I do. I don't know Minnesota rules. So we were in a Minnesota court on a matter of diversity jurisdiction, that is, citizens of different states, Walmart and the Sawyers, under Minnesota law, with the Minnesota federal judge obliged to apply Minnesota law to these facts. Among the rights we asserted was a right to self-determination. In other words, we have the right to determine what to do with our own bodies. And we had other related claims relating to interference with the relationship between the doctor and the patient. The judge unloaded on us and basically said, there is no such thing as a right to self-determination. We said, but wait, there's this informed consent case, which talks about bodily autonomy and which talks about the right to decide what to do with our own bodies. The judge's response was, well, yes, but that means you have the right to consent to treatment, and you have a right to be told about potential adverse consequences. If you're not and you suffer, then you have not had informed consent, and the physician may be liable. So this is a medical malpractice claim. We didn't bring a medical malpractice claim because we tell the judge. We brought a claim against the pharmacist who failed to perform his duty. And so the law recognizes two types of acts: ministerial acts, that is, acts that you largely do without thinking. Something appears in column A and you move it to column B, and discretionary acts, acts that require you to use your judgment. The court basically said, no, 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 no. I understand the court's instinct. That is, pharmacists play an important role, a look back role. If you go to your pharmacist and you present a script, the pharmacist looks at it and he can say, wait a minute, that's not right. That's too much. Or wait a minute, this drug might interact with another drug we're prescribing for you and it could kill you. Or wait a minute, you're physician shopping and maybe you're addicted to some unlawful substance. And so the pharmacist has the duty under Minnesota law and under the law in many states to raise these questions.
Yeah, Norm, can you stop there and talk a little bit about what that sort of pharmacist check arose out of? Was there something happening in the country in terms of like a new prescription regime or fraud or something that brought that about that could inform our listeners as to the intent of that pharmacist check?
Well, so it varies by the state because states have their own individual boards of pharmacy. This is something that falls in the federal regime into the state's police powers. That is the state's ability to regulate in the interest of the health, welfare, and whatnot of its citizens. And so, with respect to opioids, let's say, doctor shopping is a frequent phenomenon, and then there are you can get a month's worth from one doctor, go to a separate doctor, and use the same pain presentation, get another month's and so on. And then after 12 visits, you've got a year's supply, and you can then sell those pills on the market. So it helps deter that. it also is a useful second look back. I mean, I've been engaged in a Twitter discussion about this issue for the last 24 hours, and there's a guy, Philip P, I think. He's a pharmacist, and he said he once screened an error that a physician made, that if it had been executed, the patient would have died, and he was commended for it. And so I think, double checking your work, double checking the work of doctors is always a good idea. I'm not sure when, Mike, I'm not enough of a scholar in this area of public health litigation to know what particular event inspired it, but I accept the look back.
Well,
But
and I asked because, and I'm putting this on the screen. I think I incidentally threw this up yesterday, or the day before, rather, when we were talking about the Cavender twins, because it comes from the Free Press. But the article title that I have on the screen is "America's Love Affair with Adderall," and it was published just 2 days ago.
Mhm.
And the reason that I asked that question is because it seemed to me that this look back that pharmacists have could be primarily driven by the proliferation of Adderall and these amphetamines as prescription drugs for young people. I came from a generation, Norm, where Adderall was something that people were buying, like sort of on a black market, for SAT prep, for all sorts of stuff, because of the increasing exclusivity and competition around higher education acceptance and stuff like this. And what I've learned over the years is that this, and right now America, if listeners don't know, America is in what's called an Adderall shortage. The reports from United States officials are that there have been issues with Adderall being laced with fentanyl coming from
Uh-huh.
China, stuff like this. And the reason I bring that up is because it seems as though the look back at what I would at least assume, and the reason I asked you is whether there was anything within the research or within the case law that would dictate that the look back provisions, as statutorily created state to state or at a federal level, were designed to guard against multiple prescriptions or fraud for stuff like this, not necessarily to make a determination as to whether a physician erroneously prescribed something. Because as you and I both know, Norm, and as everybody watching knows, the doctor-patient relationship is sacred. It's along the same lines as the attorney-client relationship. And how is someone in a pharmacist position going to assume that they know better than a physician what to prescribe to their patient?
No, I agree. It is outrageous. I think catching the obvious errors is important. Well, under Minnesota's law, there's a regulation that requires a pharmacist to talk to the doctor. So Walmart's pharmacist calls the doctor, Dr. James, and Dr. James says, "Yes, I want it prescribed, and this is what the patient's symptoms are." And then Walmart's policy refused it. So we took the position that this interposition of corporate medicine between the patient and his physician violated some fundamental right at common law. Now, what is common? And there are a number of sources of law. There are constitutions. We have written constitutions in the United States. Constitutions are the fundamental law of the land, the law before which all other laws must bound, and presumably they will be enforced uniformly across a given jurisdiction. Then there is statutory law, that is law that it doesn't have the binding force of the Constitution, but is passed by a legislature. And then there, are executive regulations that have the force of law, administrative regulations that have the force of law, and then there's common law. And common law is law that is decided or made up by judges. And you'll say, wait a minute, I didn't think judges made up the law. Well, they do. And most of personal injury law is common law. Most of our law at the state level regarding the right to privacy and bodily integrity is common law. That is, judges recognizing fundamental principles and applying them in such a way across a variety of circumstances that those principles begin to stand alone. So the district court judge in Minnesota, the federal judge, took the position that Minnesota and no state recognized a right to bodily autonomy. And we said, even if that's true, we think it ought to. And we think the common law should be extended to preserve privacy and the right to bodily autonomy for the reasons stated in the informed consent decision. The district court judge disagreed. We asked him to do something that is a matter of comity, not comedy, ha ha ha, but comity, comity. That is, out of the courts respect the power of other courts in concurrent jurisdictions. So, for example, at the district court level, in federal court, a judge must follow the decision of the United States Supreme Court, or he will or she will be reversed. A district court judge is not bound by a decision of a state Supreme Court, because after all, that court has no power over the federal court. However, as a matter of comity, COMITY, and giving full faith and credit to the decisions of other and sister jurisdictions, courts defer to their sister jurisdictions. So, and under federal law, when a novel question of state law arises, you can ask the federal court to certify a question to the local Supreme Court. So we asked this judge to certify this question to the Minnesota Supreme Court. He refused. So I find myself yesterday in the Eighth Circuit Court of Appeals in St. Paul, Minnesota, arguing that the court should have certified this question. And it was a fascinating experience. A federal appellate court, you're standing alone on an island. You've got three judges up there, and you're one heartbeat away from the U.S. Supreme Court. So among the questions presented to the court yesterday is whether the court should have certified to the Minnesota Supreme Court whether there is a right to autonomy such that we asserted. The other side, Walmart's lawyers, and there was another pharmacist called Hy-Vee involved. They were risible of the claim. There is no such thing, and they asserted, look, they said to the judge, if you tell pharmacists they have to, fill prescriptions, what about their right to autonomy? And you'd be asking them to do things they don't believe in. And our position, and so the argument went back and forth for a while. One judge turned to me and he said, can you think of a case in which the Eighth Circuit, that is the federal court over Minnesota, I think South Dakota, I'm not sure where else, has ever certified a question to the Minnesota Supreme Court? And we'd taken a look at that. I couldn't find such a case. And I said, I can't, but this might be the one. And, and other jurisdictions routinely certify. The Second Circuit in New York, which governs New York, Connecticut, and Vermont, I've gotten certification decisions heard there, but, couldn't get it out of this court. So, we're arguing back and forth. I'm taking the position that, you don't have the Sawyers had every reason to be surprised when Walmart started making healthcare decisions about them, because who would go to Walmart for health decisions? And the judges, and they're pharmacists. And one of the judges was like, well, I might ask about this, that, and I got a little aggressive with him, and I basically said, no, you wouldn't. Not if it really mattered. You'd go to your doctor, and you'd expect your confidences to be kept and not to be shared with a corporation, and for the corporation to veto you. Then the judge surprised everyone, and he started acting as though he were the Minnesota Supreme Court, and he pulled out an old case that none of us had read, because it really wasn't on point, but it was about the Minnesota Supreme Court's right to recognize new common law causes of action. Which it indisputably has, and is why we wanted this case referred to the Minnesota Supreme Court. The case he referred to, involved it raised questions about a common carrier. And so, in other words, you and I have a right to refuse to deal with certain people, so long as the law doesn't impose a duty on us to deal with them. In an employment context, you can't refuse to offer a person employment on account of their gender or on account of their race or ethnicity. If you're an innkeeper at common law, you might have the right to refuse to let people stay at your inn for all sorts of reasons, but there are occasions in which you must take them. And that is, and it serves the public policy purpose of keeping them in a safe location, as opposed to sleeping in the bramble bushes in 16th, 17th, 18th century England. And so the judge said, would this exception apply? And he didn't raise it with me initially. He raised it with the Walmart lawyers, and they were somewhat flat-footed by this, because I don't think it ever occurred to them that this could be the case. We took the position that pharmacists, that the law makes life between strangers possible. And it imposes duties on one another, on us and one another, for the sake of a civilized society. And the common carrier, or the innkeeper's exception to the right to refuse to deal with someone, serves the public policy purpose of making it likely that individuals will have a safe place to stay, to keep them from sleeping on the streets when they're in a foreign community, and that pharmacists, like innkeepers, have something. They have a right to make money fulfilling prescriptions. And when somebody walks in with something that their doctor has considered, they have a duty to fill it. That's incident. That arises from their regulatory ability to profit, selling drugs. I don't know whether the court will agree with us or not, but I was stunned that the Minnesota court would raise the appellate court, the federal appellate court in Minnesota would raise this issue because it's an issue that properly belongs before the United States Supreme Court. And I had the impression as I was sitting there that somehow they didn't want to certify this question. They wanted to find a way to decide it on their own. And I think the right decision, if they make it, well, fine. I'm not sure how the Minnesota Supreme Court would react because, as a matter of comedy, the Eighth Circuit Court of Appeals could decide this is what Minnesota law is, and the Minnesota Supreme Court could say, no, it's not. And then where do you go? So, I mean, if you're listening, Eighth Circuit, you really do need to send this back to the Minnesota Supreme Court so that they can consider it. Our claim is a simple one. When I go to a physician and I disclose my medical condition and the physician makes a prescription, even if it's unpopular, it's on the physician that he did this. So when I present the script to a pharmacist, if the pharmacist says that's contraindicated, it doesn't suit our algorithm, once they call the doctor and the doctor gives his reasons or her reasons for the prescription, the pharmacy has a ministerial duty to fill the prescription. Otherwise, they're interfering with the patient-physician relationship.
Well, can I bring up this comment from over on Rumble? Freedom Lover says, kind of crazy precedent they set. If Walmart can say, don't fill ivermectin prescriptions, will they soon not fill an antibiotic because it's not politically correct? And I don't want to focus so much on the latter part of politically correct, but I think that the point there is the one that you're making here, Norm, right? That the doctor-patient relationship is supreme, right? That they're and not only that the doctor-patient relationship is supreme, but let's not kid ourselves about the distinction between pharmacists and physicians, right? And this is no slight to pharmacists. One of my best friends in the world is a licensed pharmacist, but with all due respect, I don't know that I would be going to that person to tell me what to take because they're not a licensed physician. They are a doctorate level pharmacist, but they're not a licensed physician with an MD. And
no, I think that matters.
It matters a tremendous amount, and it historically has, right? I mean, that is the reason that doctors and lawyers and these degree-holding professional service providers historically have been provided such an extreme level of deference in our society and have been given certain levels of respect because there is an entire knowledge base and then also a significant amount of discretion and risk afforded or I guess obligated on these people that have a lot that they're entrusted with, whether it's legal rights or whether it's health decisions. And for someone within, especially something like Walmart, right? I mean, we've all been in a Walmart, and for something like Walmart that sees so many people. I mean, how many tens of millions of people travel through Walmart stores on an annual basis, and therefore, how many people are traveling through there for their everyday routine prescriptions? And if Walmart is, it's like the position that Walmart may be taking here is we're not going to fill controversial prescriptions. Well, what does that mean for their ability to serve the needs of their customers on a day-to-day basis? If their customers are coming in with otherwise valid prescriptions, having seen their physician and their medical provider, and they're not even willing to honor, even if they do call. Because in your case, Norm, you said they did call, and the physician corroborated what they were saying. Yeah, fine, it's contraindicated. I prescribed this. I know the patient, and they still refuse to do it. So what's the point of even calling?
Well, I think that's the acid test in this case. So an interesting break in it, we've got a link to the argument posted online, and you may hear me refer to a strong case and a hard case. And so there were two pharmacists involved. So what I haven't mentioned is Mr. Sawyer's wife, Mrs. Sawyer, also sought to get ivermectin prescription fulfilled at a pharmacist called Hy-Vee. And Hy-Vee refused, and she didn't have Hy-Vee call the doctor. So our claim is that we respect the look back requirement of pharmacists to basically proof of work as to the doctor for obvious contraindications, over prescriptions, fraud, and so forth. But once a pharmacist checks with the doctor. We say the pharmacist's duty is simply to follow the doctor's orders. And so Walmart is a strong case for us. We think we win every time. Hy-Vee is an interesting case. I mean, we could well win against Walmart and lose against Hy-Vee. I think the regulation in the Hy-Vee case required the pharmacist to call the doctor, and he or she never did, and that might support an independent cause of action. But the trial judge's refusal even to consider these things, saying that we had failed under Federal Rule of Civil Procedure 12b-6, that we had failed to state a claim.
That is
relief should
wild.
be granted.
That is wild.
We thought was outrageous and left a lot to be desired. And it appeared that the district court or the appellate court agreed as well. So stay tuned. We'll have more to report on that. It'll probably take a couple months for that decision to get made. And I hope that we go to the Minnesota Supreme Court on this issue. I hope the Eighth Circuit doesn't address it on the merits, because while the Eighth Circuit panel raised an interesting common law analog, that is the innkeeper, the innkeeper problem that I mentioned before. Nobody raised that as an issue to brief at this point. And it's not for the federal courts to determine state common law torts. It's for the state courts to do so. And as a matter of comity, notwithstanding the Eighth Circuit's great reluctance to certify questions to local Supreme Courts, the right decision is for them to break precedent and certify this to the Minnesota Supreme Court. We may lose there, but the Minnesota Supreme Court, as the appellate court noted yesterday, does recognize that common law is evolving, and it evolves to meet the necessities of the times. And given the divisions within the medical community about treatments such as ivermectin and so forth, we think it's ripe for review in the Minnesota Supreme Court.
Well, and it's almost as if, again, I go back to this issue because I think what you referred to it in the oral arguments, and for anybody who's in the chats this morning, I have posted the links to Norm's oral argument in there. I do highly encourage you to take, 15, 20, 30 minutes if you have that amount of time and listen. Norm, you're great on your feet. Not that, you need to hear that from me, but it really, really great stuff, especially for aspiring attorneys to hear. But I think my issue is, so you use the phrase corporate medicine a couple of times in your oral argument. And I think that the panel of judges picked up on that a little bit as well.
They didn't like it.
Well, of course they didn't, but isn't that ultimately what this comes down to? What I sense from Freedom Lover in the chat and a few other people is this creeping sense that for exogenous reasons that we don't have control over, a certain course of treatment can be categorized as whatever you want to call it.
It becomes rationing, basically. I mean, rationing is a decision about how to allocate resources. And so if we have a medical establishment that decides that treatment X and Y is appropriate, but treatment Z isn't, that's a rationing decision. And it deprives doctors of the ability to choose Z. And it deprives the patient of the right to have his or her doctor's orders followed if the doctor chooses Z. Now, it may be that there are certain things that we want to categorically place beyond the reach of physicians, assisted suicide, for example. But prescribing ivermectin is not that. And so I think that, if you're going to make qualitative decisions about what cannot be done between a doctor and a physician, you're only one step away from a quantitative decision. Well, that's an expensive prescription. We'll give it to a patient below the age of 70, but at 71, I mean, they're getting pretty close to their sell-by date, so we're not going to fill that. And I think that's the danger with algorithmic medicine. And when a pharmacist is asked to fill a prescription and they don't know the patient, and they're following guidelines from their employer, that's corporate medicine. That's diagnosing society and saying how society should allocate its resources. And that's depriving a physician and his or her patient of the right to make their own decisions.
Well, and ultimately, without that level of push and pull, it's fine if a company like Walmart wants to, as a general rule, say, in the absence of you being able to reach the physician and be able to confirm, especially if something is contraindicated or presents an issue for you, to refuse to fill it unless and until you can reach the physician and they can confirm. My issue, I think, is I love where you're going on the quantitative versus qualitative thing. And I think where I was going was, what happens to innovation within the entire American medical framework if we have now disemboweled the doctor-patient relationship as a means by which these two individuals can come up with strategies for addressing medical issues as they arise. Doctors are not required to be correct, right? They're allowed to be wrong.
No, and the standard of care, that's the whole point of the informed consent doctrine. A doctor will prescribe a course, but it comes with risks. And so you say to the patient, I'm going to give you this. There's a 20% chance it won't work. There's a 5% chance it's going to kill you. But there's a 95, whatever the numbers are, there's a chance that it will work. Are you willing to take the risk? And a patient should be able to make that decision without the interference of a pharmacist, or more to the point, as in the case of Walmart's corporate decisions about what it will and won't do. Because, let's face it, Walmart is a huge pharmaceutical industry or portal, and it's doing a lot of purchasing from pharmaceutical companies, presumably at a discount on the bulk it buys. Are the pharmaceutical companies saying prescribe this and not that, and there's going to be a little something in it for you? I'm sure that occurs, and I don't want Walmart making medical decisions for me, period.
I agree. Well, Norm, we're up against it. I know you're waiting on a special delivery there for you. So
yeah, so I came back from Minnesota last night, hopped an earlier flight since the argument went quick, and came up to Vermont, but the airline lost my bag last night. So I'm sitting up here without my laptop, which I need because I've got a brief I've got to get written this weekend, and hopefully it'll arrive this morning. Otherwise, I'll be back in New Haven tomorrow morning where I can find a computer.
Well, it's great to be back in the saddle. I know it was only a one-day hiatus, but it felt like longer than that. We certainly had a number of you reaching out. Matt, thanks for reminding us that you need your LAL fix. Norm will be back on Monday morning unless you and I otherwise decide to try and do something over the weekend. But I think the safest bet is Monday morning, 8 a.m. You can find us here on Twitter Live, YouTube Live, and Rumble. And if you don't listen to us live and you catch us after the fact, you can do so by audio only on Apple Podcasts, Spotify, Google Play, Overcast, etc. Rate us 5 stars or don't rate us. Don't be in between. And more than anything, share the stream with somebody care about. I think, Norm, what's been interesting, I was talking to my law partner Cam about this yesterday. The Rumble views and everything have started to tumble, but I have never personally felt more traction for what we're doing. So those two things are at odds. I have a number of you reaching out on a day-to-day basis. Our follower counts are growing across all platforms, and it seems like the engagement is extremely high. So we're going to ride this out, and we're not going to worry about the numbs, as they say. I'm having a great time, and Norm, thank you for showing up and disclosing what is really, really important and interesting work.
Yeah, it's fun stuff. I mean, I enjoy it, and I'm glad you all tune in to listen. We're we aim to be on the front lines of the issues that define our lives and your lives, and so we're open to hear from you, and we're open to litigate your cases too.
Absolutely. Well, we had 2 stories today we didn't get to. Number one was Tucker on Twitter's 4th episode calling Biden it was actually Fox News calling Biden the wannabe dictator on a cryon, and then trying to walk it back. Then we also had a new law that was passed in the European Union aiming to regulate artificial intelligence. So perhaps we will pick up one or both of those on Monday, but certainly are going to keep track on the AI stuff.
We sure will. It's a great story. Yesterday's Washington Post. Europe forges ahead on AI rules. Give it a look, folks. It's important stuff. It's coming here soon.
All right. Thank you, Norm. Have a good weekend. Get some rest. After all that travel, we'll see you on Monday.
Will do.
Bye.